man is wheeled unconscious. A man is wheeled unconscious into an emergency ward. Nobody asks him to review a notice. A cyclone tears through a coastal district and relief teams process thousands of names and locations with no consent screens in sight. A company receives a court order for an employee's records and no withdrawal right can countermand it. If yesterday's legitimate uses were the law being sensible about cooperation, today's are the law being sensible about necessity. The situations where waiting for consent would be absurd, impossible, or unlawful. But necessity has a shape, and every ground today is drawn to fit it exactly. Today, the state cluster, the legal cluster, and the emergency cluster, the second half of the closed list, and the one guardrail that runs beneath all of it. You're listening to DPDP Daily. I'm Harmeet Singh Kapoor. I've spent my career running large programs and portfolios, the discipline of making complex things actually happen. And for the past few years, I've brought that discipline to India's data protection law. I wrote the DPDP Act Compliance Handbook, From Law to Ground Reality, and this show is that book, opened up one episode at a time. If you're new here, the 30-second background. In 2023, India passed its first comprehensive data protection law, the Digital Personal Data Protection Act. In November 2025, the government notified the rules that make it operational on a phased clock that runs to full enforcement in May 2027. Together, they decide what every company, hospital, school, app, and shopkeeper in this country may do with your personal data and what you can demand when they get it wrong. 15 minutes a day, no jargon, real answers. Let's get into it. Begin with the state cluster because it's the one most listeners meet as citizens before they meet it as professionals. The Act permits the state and its instrumentalities to process personal data without consent for defined governmental purposes, providing or issuing subsidies, benefits, services, certificates, licenses, and permits with a sensible efficiency built in, where you've already consented to processing for one benefit or your data already sits in the government's notified databases, it can be processed to deliver the next one without a fresh consent, round trip. The design intent is unmistakable. The welfare state's plumbing, the ration entitlement, the pension, the scholarship, the license renewal shouldn't stall at a consent screen for the person it exists to serve. Add to this the broader ground for the performance of statutory and sovereign functions, and you have the lane government programs drive in daily. Two honest annotations connecting threads this show has already laid. First, this cluster is distinct from the Section 17 exemptions we debated in episode 12. Here, the Act applies and provides a basis. There, provisions are switched off entirely. A department using this ground still operates inside the Act's discipline. An exempted instrumentality steps partly outside it. The difference matters enormously to what citizens can demand, and conflating the two is the most common analytical error in public commentary. Second, for the businesses listening, this cluster belongs to the state. A private company delivering services adjacent to a government program doesn't inherit governmental grounds by proximity. Your basis analysis, as always in this arc, is your own. Next, the legal cluster, processing necessary for compliance with any law or with any judgment, decree, or order, Indian and in defined respects foreign judgments relating to contractual and civil claims. This is the ground that resolves 1,000 daily conflicts before they start. The bank retaining KYC records because banking law commands it, the employer disclosing salary data under a court's garnishee order, the platform producing records under a lawful demand, none of this waits on consent, and none of it falls to a withdrawal, which is precisely the some processing survives boundary we drew in the withdrawal episode. The compliance craft here is specificity, compliance with law, means an identifiable legal obligation you can cite, the provision, the order, the direction, not a vague gesture at the regulatory atmosphere. When I review basis maps, entries reading legal requirement without a citation go straight to the follow-up list. Entries reading retained under RBI KYC Master Directions, prescribed period pass. Same lane, different rigor, and only one of them survives a hearing. Then the emergency cluster, where the law's humanity is most visible. Processing without consent is permitted to respond to a medical emergency involving a threat to life or the immediate health of the individual or another person, to provide medical treatment or health services during an epidemic, outbreak, or other threat to public health, and to ensure the safety of or provide assistance or services to individuals during disasters and breakdowns of public order. The unconscious patient gets treated, the contact gets traced in the outbreak, the relief camp registers survivors, and the law stands aside, as it should. For hospitals and healthcare listeners, this cluster deserves protocol level clarity, and here's the discipline my healthcare chapters push. Emergency grounds are event bounded. The crisis justifies the processing. The crisis requires while it lasts. The emergency admission doesn't convert the patient's data into marketing material for the hospital's wellness packages. The epidemic era database doesn't live on as a commercial asset after the outbreak ends. Process under the emergency, document that you did, and when the event closes, the ordinary rules resume. Retention schedules, purpose limits, all of it. Trauma wards should never host consent theater, neither should emergencies host purpose creep. Which brings us to the guardrail I promised, the one sentence that disciplines the entire lane. No legitimate use in this list spells marketing. Read the closed list end to end, voluntary provision for its specified purpose, employment, state functions, legal compliance, emergencies, disasters, and notice what never appears: promotion, advertising, growth, engagement, monetization. The lane exists for cooperation, obligation, and necessity. The moment your processing purpose is commercial persuasion, you are in the consent lane, full Section 6 standard, no exceptions, and every clever attempt to smuggle marketing through a legitimate use is just the purpose creep violation from yesterday wearing a costume. If one sentence from these two episodes reaches every marketing team in the country, let it be that one. Let me close the lane with the full picture discipline, because episodes 18 and 19 together now give you the complete second door of Section 4. Your basis map, the homework running since episode 14, should now be finishable. Every processing activity in your organization attributed either to Section 6 consent with its logging behind it, or to a named Section 7 ground with a one-line fit statement. And here's the audit honesty test for the finished map. The legitimate uses column should be shorter than the consent column in most consumer businesses. If your map claims the reverse, if most of your processing somehow rides without consent, you haven't discovered a clever architecture, you've documented your exposure. The lane is real, useful, and honorable. It is also narrow, and it was built narrow on purpose. That was the whole story of episode 5's drafting history, where deemed consent died precisely so this list could be trusted. Tomorrow, the arc turns from bases to burdens. Section 8, the general obligations of every data fiduciary, the provision that quietly assigns responsibility for accuracy, security, erasure, and grievance machinery. And the reason we're compliant because users consented has never been the end of anyone's obligations. That's today's episode of DPDP Daily. If it made this law a little clearer, do one thing for me: send it to one person who needs it. That's how this show grows. Everything I covered today, with the templates, checklists, and audit frameworks behind it, is in my book, The DPDP Act Compliance Handbook: From Law to Ground Reality. And I post one practical DPDP insight every morning. Find me on LinkedIn and on X and Facebook as well under Harmeet S. Kapoor. One important note, this is education, not legal advice. For decisions about your organization or your rights, take proper professional advice on your specific facts. New episode every day. I'll see you tomorrow.